application and appeal in the matter of Lifestyle Equities CV and Rule 20 of Berkshire, Polo, Club Limited and others.
Mr. Edinburgh.
My Lords, I, Mr. Edinburgh, and my learned junior Thompson Quinton appear for the Claimants, Lifestyle Equities, and my learned friend, one of his King's Counsel, Mr. Silverleaf, appear for the defendants. That's D1 to 5 in this case.
Yes.
D1 and D4 are corporate entities, D2, 3 and 5 are natural people. My Lords, just to check some housekeeping, I trust that you have all been delivered the core and supplementary bundles and the defendant's application bundles, either in hard or soft copy as your Lordships wish.
Yes. We've read the essential documents. We've read the skeleton arguments. We've read the judgment below. My colleagues are very familiar with the case law.
Yes.
I'm less familiar.
Exactly.
You have to remember that the convoy has to move at the pace of the slowest ship, which in this case will definitely be me.
My Lord.
Now there's a late application by the respondents.
My Lord, yes.
What we thought about this, Mr. Silverleaf, would be this. We think we'd like to hear the appeal first, the arguments on the appeal for which we prepared, then take stock and see where we are, whether we want to or need to hear your application.
I'm entirely content with that portion of order. If you had not suggested it, I would have done.
Have you had a thought, Mr. Edinburgh, between you as to how long this is going to take? There's a lot of interesting case law cited, and it's a complicated case on the judgment, but the issue is relatively for this area law straightforward. And is it going to take a day and a half?
My Lord, I'm glad you raised that because I went through yesterday and timed myself, so to speak, and realised that's inaccurate because it takes into account...
You haven't done the whole thing in front of a mirror, have you?
Not quite.
I mean, I know that lawyers in this field, enjoy their arguments, but
no, my Lord, I wouldn't wish the mirror to suffer with my reflection. But my Lord, to indicate the result of that exercise, I think I should finish this morning.
Yeah.
It takes less time than I had thought it might otherwise take. I have trimmed some of my submissions as well. So therefore, there's a sporting chance that the substantive appeal will finish today, my Lord.
Good. All right. Well, then we will be able to take stock.
My Lord,
in the way
yes.
that I've described. Okay. Right. Well, let's get going.
Can I,
my Lord,
raise one other point of housekeeping? If we get on to the respondent's application, there's a number of authorities cited in the arguments, which myself, I don't think I've seen copies of those authorities. Is that something that's in hand? Or?
My Lord, we're actually waiting for your indication. The reason we have not included those within the authorities bundle is because we quoted fully from them within the skeleton that we put in, so as to try and minimise the need for that. But if your Lordships like, we can deliver hard and soft copies as and when you direct.
Well, it might be a good idea to get that in train.
My Lord.
If it's not too much trouble.
No. We didn't know which way you wanted to play it, so we've anticipated.
I mean, if we do finish the argument on the appeal today, well, let's see how we go. All right.
But I can say that the quotes within the skeleton that we put in are really quite fulsome, and so therefore there ought to be little need to go anywhere further. My learned friend hasn't indicated he wanted other passages read, but that may be how he's going to deal with it later.
Okay. Right.
My Lords, this is my appeal, and as you're aware, that permission to appeal was granted by the trial judge, Mr. Justice Mellor, and there are two grounds. The first ground I might call the crowded market point.
Yes.
And there are three subsidiary issues within that. And then there's the post-sale confusion ground. That is conditional upon the first ground meeting a favourable reception. So it's a conditional ground of appeal. That's all recorded within the notes that the judge put forward when he was granting permission. My Lords, for completeness sake, There was also an application by the claimant to add a third party to the appeal. That is because there's been a corporate...
Change of ownership.
Exactly so.
That's agreed, isn't it?
My Lord, yes, it's agreed by the defendants, and my Lord Justice Arnold granted the order yesterday.
Yeah.
So that I need to spend no more time on. But it's for your note because there'll be an extra party on any judgment that your Lordship's issue.
Thank you.
And finally, by way of introduction, my Lords, pursuant to Lady Chief Justice Baroness Carr's direction from November last year, subject to your Lordship's permission, my learned junior would like to address you upon the defendant's or respondent's amended respondent's notice.
As and when we get there.
Exactly so, my Lord. That again is conditional upon your Lordship's view of the substantive appeal.
Yes.
But if we were to get there, then again, subject to your Lordship's view, my learned junior would like to address you upon that.
Well, very pleased to hear the Lady Chief Justice's direction being followed, Mr. Edinburgh. Thank you.
So, unless there's any other housekeeping, I was going to give a brief overview of the case.
That would be helpful.
My Lords, this is all contained within the core bundle, and you'll see from the very first tab, sorry, my mistake. It's behind tab 8. This was the claim form, so it's page 166 of the core bundle.
Tab 8. Tab 8.
Tab 8, my Lords, page 166. So the claim form was issued in 2018. The relevance of that is that your Lordships are sitting as an EU appellate trademark tribunal. But I don't believe that there's any other Brexit issues beyond that. You'll see that the claim form is quite multicoloured, and that's because there are a number of amendments made before matters were served. So the first 4 amendments related to various technical details where certain defendants were added and then removed, and then there was some tidying up with respect to certain trademarks, and then the 4th amendment pre-service was to add the invalidity of the first defendant's trademarks. There were 2 amendments made after service. So the 5th amendment related to the fact that there was now an allegation relating to the invalidity of the first defendant's what we call additional UK trademarks. This arose because in the UK intellectual property database, for whatever reason, the first defendant had a number of different ID numbers. And so therefore, when we finally searched, we realized there were about 4 different ID numbers and found a number of different trademarks that we needed to add. And the last, and also with respect to the 5th amendment, there was a change in the pleading with respect to the conspiracy to injure by unlawful means. That arose because of the judgment of Mr. Justice Morgan back in 2018. There was a preliminary application by the first, second and third defendant to strike out the claim for a number of reasons. One of the results of that was that the conspiracy to injure by unlawful means pleading was perfected but not struck out. The 6th amendment was a technical amendment to add the personal representative of the second defendant. So while the claim form contains a large number of different colours, the actual particulars of claim only has 2 sets of amendments. Might I then take you to the particulars of claim so that we can very briefly see the case? The first point is at paragraph 2 of the particulars of claim that you can find on page 172. And very briefly, you can see the logo device in the middle of that page. That is, in essence, the trademark upon which the claimants claim their rights and are endeavouring to enjoin the defendants. And then if you go to paragraph 51 of the particulars of claim, which you'll find on page 188, you'll see the representations of the various allegedly infringing signs. For current purposes, sign 1, which is the top.
Yeah, sign 1 is the top, isn't it?
Yes.
And then, and sign 3 is the third one on this.
Exactly so. The other signs have much less significance and fall away for various reasons. Sign 1 is the historical sign that was used by the defendants, use of which was stopped. I'll come to that in more detail later. And the current sign is sign 3, which is the one pretty much in the middle of the page. And because I'm doing a sort of general introduction, might I draw your attention to the allegations with respect to joint liability. I realise that this is all conditional, but it's probably sensible logistically to deal with it now. The two principal places where they are discussed are paragraphs 42 and 109, which may be found respectively on pages 183 behind tab 8. So this is the allegation with respect to joint and several liability with respect to the various defendants. And then there is further pleading at paragraph 109, which may be found at page 208 for your note. This is part of the amendment that was introduced because of Mr. Justice Morgan's decision on the strikeout application with respect to the unlawful conspiracy allegation. Then, the long and the short of it is, of course, the defendants say there is no trademark infringement. And originally, the defendants, the 5 defendants that appear before you now, were represented separately. And originally, the defendants 1, 2, and 3 put forward a defence which may be found behind tab 9. And because it's convenient to do so now, their pleading with respect to joint liability is contained in paragraphs 17 and 19 of that document, which may be found on page 220. So there's 2 points to notice here. The first, in paragraph 17, is a straightforward denial of liability, joint liability. And then in 19, there's a plea that the position in relation to joint liability is different in each of the territories, foreign territories, and therefore they're going to plead further to that, further within that document. Now, that arose because the way in which the trademark allegation plea was put was that the trademarks to which I showed you in paragraph 51 of the particulars of claim, those are the trademarks of the first defendant. And even though the first defendant does use directly those trademarks, and in particular the first and third trademark within the United Kingdom, that use is very little. It's confined historically to, in essence, a stall on the club grounds. The principal use was overseas, and the way in which that use was organised was through a licensing agency, which is the fourth defendant. And
this is sign 3. is it?
Well, there were actually licensing arrangements with respect to 1 and 3.
1 and 3.
But the real point is still 3 because
Yeah.
that's the live sign now, my lord.
Yes.
But the point being is that the 4th defendant arranged for some licenses with respect to overseas people, and those are the 6th to 11th defendants. Now, they do not appear before your lordships and did not appear before the trial judge. But there was allegations of infringement in different countries, Panama, Chile, Peru, Mexico, and the UAE. And the way in which that was put was that the claimants own different trademark rights, but very similar trademark rights in those jurisdictions, and that various defendants, D6 to D11, allegedly committed trademark infringement in those respective jurisdictions pursuant to a license that was arranged by the 4th defendant of the First Defendant's local trademark rights. And so that's why, with respect to the joint liability allegation, the defendants in paragraph 19, to which I just drew your attention, say that the issue of joint liability is or ought to be determined with respect to issues in the local jurisdictions. Now, with respect to the 4th and 5th defendants, as I said, they were represented originally separately, and you will find their original defence and counterclaim behind tab 11 of your bundle. And there's 2 particular points to which I'd like to draw your lordship's attention, and that is, starting at paragraph 6 of the re-amended defence, which may be found at page 249, there's in essence a plea that there is no infringement for the reason, or various reasons, that the use, in essence, it amounts to insignia or club badges. And this is developed such that on page 251, in paragraph 6L, alternatively, if and to the extent that reasonably observant and reasonably well-informed consumers fail to distinguish between the logo, that's the logo I showed you of the Beverly Hills mark, and the signs used by competing traders comprising a name and depiction in some form of a polo player on a horse. The logo is not a unique badge of origin associated with the claimants, and is not capable of distinguishing the goods of the claimants from the goods of those of other traders. And then in subparagraph M, in the premises, the European trademarks and the UK mark are liable, and this is important, to be declared invalid as not meeting the requirements of Article 4A and or 7.1b of the regulation, that's the EU trademark regulation, or Section 1.1 or Section 3.1b of the Trademarks Act 1994. And so therefore, what has been put forward there by the 4th and 5th defendants at that stage is that the claimant's logo is non-distinctive, but non-distinctive originally, and so should be declared invalid. It was bad purportedly at the time of registration, and that is to be contrasted with an allegation that the mark, the logo, has become bad subsequently because of the acts or inactivities of the claimants. And if that were the case, then the logo, the mark, would be liable to revocation. And that's a point upon which I will draw a distinction later.
Is there a counterclaim to that effect?
My lord, yes. If you turn the page through to 256
yes.
of that tab, can you see that paragraph 6L, 6N and 18 are repeated?
Thank you.
And you can see in paragraph 28 that counterclaim, therefore the marks are liable to be declared invalid.
So is the point that by saying Beverly Hills Polo Club, all it's doing is saying there is a polo club in Beverly Hills and this is their insignia?
Yes.
And there isn't in fact a polo club in Beverly Hills?
Well, there is actually,
But not yours?
unrelated to the claimant.
Right.
We only actually found that out afterwards.
Is it called the Beverly Hills Polo Club?
My lord, as far as I'm aware, yes. But sorry.
I mean, I don't think this is actually an issue in the case, but tell me if I'm wrong. Is that not misleading the public?
My lord, that was an allegation that was put forward at one of the preliminary hearings, and that was held not to be so.
Can you explain to me why not? I mean, if there is a Beverly Hills, I assume there wasn't one, but if there is a Beverly Hills Polo Club, does not your logo suggest to the even quite discerning public that they're the origin of your goods? I mean, I don't want to take up points that are not really an issue, but just as a matter of interest.
Yes. The long and short of it is it's not deceptive because it doesn't go to a relevant characteristic of the goods in question. It's actually contained within, I think, the judgment of Mr. Justice Morgan. Shall I give you the reference to that, and then, if you wish, you can...
I can follow it up. Yes, that would be helpful. Thank you.
In the bath, yes.
The neutral reference is 2018 EWHC 3552 Chancery. And if you prefer, my lord, it's actually reported in the Fleet Street report in year 2019. Fleet Street report, case number 14.
Thank you very much.
There are, my lord, other interim decisions
Yes,
in this case.
I'm not surprised.
At least two others. So I just put that forward in case you suddenly find one and find it's a different year. You might well have stumbled upon one of the others. Right. So,
But in any event, it's nothing we have to concern ourselves with.
no, in my submission, my lord, that is something you can safely put to one side. It has been addressed and dealt with, and the mark is not deceptive.
Yeah.
If it were, we wouldn't have reached this stage, my lord.
Well, that's right. Yes.
So, the next point to which I'd like to draw your lordship's attention in the defence and counterclaim put forward by the fourth and fifth defendant is that in paragraph 13 on page 253.
Yes. This is the admission.
My lord, yes. I mean, I'm only dealing with this because it's more efficient.
Mapping it out
No, but-
so that if we
yeah.
get to it, we've had
Exactly.
the- we've had
Otherwise,
it.
somebody's going to have to take you through the same documents.
Well, that's helpful, Mr. Edenborough. Thank you. So that is the admission which is
Yes.
sought to be
Withdrawn.
Withdrawn. Yeah.
Yes. And I mean, it's understood that that's an admission within the context of this case. Obviously,
Yes.
that's the way in which these things work.
Yeah.
There's no wider admission than that, and it's an admission between D4 and D5 of their intra-C activities. What is interesting, but only from a historical perspective, is if you turn to the previous page, 252, this was the pleading when the fourth and fifth defendants were separately represented from the first three defendants, and they were then, and this is in the struck through part of the pleading, the green struck through part of the pleading, were saying that the first defendants were jointly liable. When they joined forces and they settled their differences, that was struck through because, of course, they wanted to try and adopt a more unified approach that was better for the whole five of them. And you couldn't have an argument between one part and the other, so to speak. So that had to go. So the dispute is, in some senses, quite simple. It is, we say that there is a conflict between the claimant's trademark, the logo that I showed you, paragraph 2, and in particular the third sign, which was at paragraph 51 of the particulars of claim. This has to be in the context of the fact that the goods are identical, because they're both referring to clothing goods.
Polo shirts, are they?
Yes, in particular. But the relevance is that what one is looking at are goods that are clothing, which are unrelated to the sport of polo. They might have a horse and rider theme, but the goods for which the marks are registered and the signs are being used in relation to are clothing goods, and they've got nothing to do per se with the sport of polo or a polo club per se. And this is a point that I'm going to revert to repeatedly, I'm afraid, because there is nothing descriptive about those marks or signs vis-a-vis the goods, the shirts. Now, they might allude to the sport of polo, but we say that that is actually irrelevant. Now, very briefly, by way of to close this part of the introduction, there were other allegations. I mentioned them because basically you can then hear about them and put them to one side. There was an allegation of passing off. There was an allegation of conspiracy to injure by unlawful means. There was an allegation with respect to the invalidity of the defendant's trademarks and additional trademarks. That arises because of the alleged conflict with respect to the signs with the claimant's trademarks. And there's a further allegation that some of the additional trademarks should be revoked for non-use. That actually took up little time in the end because some of it was admitted. The judge mentioned at paragraph 338 of his judgment, which just for your note is behind the 6th tab at page 139. I don't really need to take you to it, but he was slightly bemused, was his word, as to why the allegation of conspiracy to injure by unlawful means was pleaded. If the judge had asked me, I would have given him the following answer, and that is, it was because you can see from the way in which I've opened the case, the principal allegedly infringing activity was overseas. D1 did do some allegedly infringing activity within the jurisdiction from its club that was based in England, but the bulk of it's overseas. And yet we wanted, that is the claimants wanted to sue the defendants in the United Kingdom, in England and Wales, not overseas. And so we needed to secure jurisdiction, and the conspiracy to injure is a mechanism whereby you can secure jurisdiction against the overseas tortfeasors. Very briefly, a number, excuse me, my lords. Very briefly, there were a number of counterclaims that were raised. One is the action for threats for bringing proceedings, unjustified threats for bringing trademark proceedings. That's a quid pro quo action that if you make a threat for an allegation of trademark infringement and that turns out to be unfounded, then the defendant has a freestanding claim against the person who made the threat. So it commonly follows the success or otherwise of the infringement action, even though in this particular case there were other defences that were made in that regard. There was an abuse of process claim, and also there was a claim by the fourth and fifth defendants, as we've already seen, for the invalidity of the claimant's defendants. And I've already pointed your lordships to that. Now, you've seen that there's the main judgment behind tab 6, but behind tab 7, you'll find the consequentials judgment, or the form of order judgment, dealing with obviously things like costs and declarations. The main point was to deal with the application of the defendants for an anti-suit injunction. This related to their allegation that the whole process was an abusive process and they wanted protection by way of anti-suit injunction. That was actually not successful, and in essence led to the fact that the costs of that application were a score draw, so to speak.
And that's not appealed.
Correct, Lord. But I bring it up to show you expressly that the abusive process was followed through at the consequence.
All the way?
Yes. Because it is relevant to one of the submissions I'm going to make later. My lords, that was all I was going to say by way of introducing the case.
Thank you, that's very helpful, Mr. Edinburgh.
I've already dealt with the claimant's application to join a third appellant. That my Lord Justice Arnold has dealt with yesterday, so that's gone. And that then brings me to the substance of my appeal. If you're still in the core bundle, you will find the grounds of appeal behind tab 1, starting at page 14, and you'll be pleased to know they only just go into page 15.
They do.
They're not that long, he says. So the first ground has two principal parts. 1A, the judgment wrongly relied on the existence of other polo-themed trademarks. It was wrong to do so in particular because those other brands were not relevant as a matter of law. And then little Roman 2 did not form part of the relevant context. That's a different way of reaching the same conclusion. But one is a matter of law and one is a matter of context. And then little Roman 3, because basically there was no proper evidential basis upon which to reach that conclusion. And then 1B, the judgment wrongly relied on the terms of various coexistence agreements. So that's a separate point which the trial judge recognised was sort of wrapped up, but it is a freestanding point. And then the second ground of appeal, which is a ground of appeal that is completely dependent upon ground 1 succeeding.
Yes.
But only succeeding in part. So if ground 1 succeeds, that the judge was wrong to take into account polo-themed, other third parties' polo-themed activities, then there's a separate point that he failed to consider, and that is, instead of just looking at the existence of the likelihood of confusion at the point of sale, so in the shop or what have you, ground 2 goes to the fact that he should have looked at the post-sale situation. That's clearly contingent upon ground 1, and that's reflected in the way in which the grounds of appeal are put forward before your lordships.
So if you fail on ground 1, ground 2 doesn't do you any good.
Correct, my lord. Because if the judge were right, then it doesn't matter because there's no confusion.
And if you succeed on ground 1, do you need ground 2 for your appeal to succeed?
No. I only need ground 2 if I succeed on ground 1 to the extent the judge was wrong to take into account third-party polo-themed activity, but he was right to hold that there did not exist a likelihood of confusion at the point of sale.
Got it. Okay.
But he was wrong to hold that there was no existence of the likelihood of confusion post-sale.
Thank you.
It is a fallback position.
Okay.
But one is permitted to divide those two scenarios. The case law on that's relatively clear, but I'll come to that in due course. So, I was going to take 1a, little Roman 1 and little Roman 2 together because they flow one from the other. And this is the fact that the crowded market, I'm going to use that shorthand, is irrelevant as a matter of law, little Roman 1, or as a matter of context, little Roman 2. And by way of background, your lordships, and I don't think I'm stretching judicial notice too far to say that you're probably aware of Ralph Lauren, and they have a series of clothing which they to which they attach a logo which has a horse and rider on it. Ralph Lauren, by common agreement, is the biggest player in the world with respect to such emblazoned artifacts, clothing.
And the first, historically?
Yes, actually.
I think that's what the judge says.
Yes. Doesn't always happen, but that is the case here. And the second biggest player is US Polo Association. And just so you can see what all those look like, if you go to the core bundle, tab 2, and this is my appellate skeleton, and in paragraph 42, on page 31, you can see the Ralph Lauren logo. Now this one has got Polo and Ralph Lauren, but sometimes it's just the logo, the horse and rider. And you can see that that is a horse and rider running towards you. So it's quite a narrow portrayal of the logo. And then if you turn the page under paragraph 42.2, you can see the US Polo Association, and you can see that's two horses and riders running towards you. So it's a far more complicated logo with clearly multiple horses. Now, just one point about authorities, my lords. Are you using hard copies or electronic? I don't mind which. It's just
hard for me.
Yes, we're all on hard. We have, two of us have computers in case we get stuck.
fine. It's just because I was only working off soft, and I then realised that your bundles are divided into 3.
Is the numbering not the same?
No, the number is the same. It's just so I can direct you to each bundle.
Okay. Well, we're all working off hard copy.
The first case is the Specsavers when it first went to the Court of Appeal.
Yeah. Is that volume 1?
Volume 1, tab 4. And the relevant paragraph to which I'd like to draw your attention is paragraph 87, which may be found on page 223. In my judgment, the general position is now clear. In assessing the likelihood of confusion arising from the use of a sign, the court must consider the matter from the perspective of the average consumer of the goods or services in question and must take into account all the circumstances of that use that are likely to operate in that average consumer's mind in considering the signs and the impression it is likely to make on him. The sign is not to be considered stripped of its context. So that's the starting point. You need to, when assessing the existence of the likelihood of confusion between the allegedly infringed trademark and the allegedly infringing signs, look at the matter in the round, so to speak, considering all the circumstances, not stripped of context. This case then went to the Court of Justice on reference, and the relevant part we may find on that is in the authorities bundle tab 24, which is going to be bundle C, I believe, for you. So bundle C, tab 24. And if we go to page 994, I'd like to draw your Lordship's attentions to paragraph 34 and 36, because already we start getting qualifications on the opening phrase of all the circumstances. 34, concerning in the first place the assessment of the likelihood of confusion within the meaning of Article 9(1)(b) of the regulation. It should be recalled that, according to settled case law, the existence of a likelihood of confusion on the part of the public must be assessed globally, taking into account all the factors relevant to the circumstances of the case. Then that quotes the classic examples of Zabel and Medium. And if you go to paragraph 36, furthermore, according to the case law of the court, the more distinctive the trademark, the greater the likelihood of confusion. Therefore, trademarks with a highly distinctive character, either per se or because of the reputation they possess on the market, enjoy broader protection than trademarks with a less distinctive character.
So, question rising at that point. In one of my judgments at first instance, I pointed out that certainly as at that date, I forget which judgment this was, it might have been Enterprise and Eureka, the Court of Justice had not expressly stated the converse proposition, but I suggested that as a matter of logic it must follow. Would you dispute that?
Well, my lord, the answer is yes and no, I'm afraid, and that is because we say that you have to take into account how distinctive a mark is when you're assessing the existence of the likelihood of confusion. You can at no stage, when doing that, reduce it to nothing, because that would require a different mechanism to do that. I was going to come to that later, my lord, but in brief, it's because until the mark has been removed by revocation, it must have some distinctive character.
Why?
Because if it's still on the register, my lord, it must be distinctive as a matter of law.
I don't understand. I understand that's the submission. I haven't understood why. You can register what you like. So suppose you register an entirely ordinary word, water. It's liable to revocation because it's not distinctive. But so long as it's on the register, it doesn't make it distinctive as a matter of law, does it? Or does it?
Yes, it does.
Why?
Because if it's on the register, it has to be distinctive. while it's on the register, it must be treated as distinctive. It might have low distinctive character, but it must be distinctive. Only once it's been expunged from the register can it then be treated as not being distinctive. But the word water, for example, is not distinctive for aqueous media. But if it were being sought to be registered for such goods, it would never get on the register in the first place. But it is distinctive, for example, for banking.
Okay.
Water has no elusive connotations to the provision of banking services. And in this case, a horse and rider have no elusive connotations to clothing.
Yes, but to come back to my original question, excluding the case where the mark has zero distinctive character, do you accept that as a matter of logic, the converse proposition must be true? Namely, trademarks with a lower degree of distinctive character enjoy less broad protection than trademarks with a more distinctive character.
Yes, my lord, because that must be, that just follows from the fact that if you have a starting point of in the middle, they get more protection if they're greater, have more distinctive character.
Okay, thank you.
That follows from paragraph 36. Now, but there's a...
Now, second question. This is the most recent judgment of the Court of Justice that has been cited, and it's now 11 years old. I take it from that the researchers of counsel on either side have not revealed any decision of the Court of Justice which has any bearing on the issues before us. Am I right?
Arnold, that's a significantly loaded question to which I'm going to answer. As far as I'm aware, yes. That is.
I'm not telling you that I can think of one.
No, but
in the intervening 11 years. But on the other hand, there's been quite a lot in the intervening 11 years. And it's not my judge to research the case law, it's your job.
Yes, I know that, my lord.
Although my lord may have researched it.
Yeah, that's exactly why I'm cautious, my lord.
I can well understand your caution, Mr. Eden.
I'm wondering how close to the minefield or how deep already I am in it, basically. But, my lord...
If it's any help to my learned friend, all that I have managed to find is the Court of First Instance in Castellani, which is even older, which is at tab 21. And is concerned...
We'll come to that in due course.
You'll come to that in due course. It's concerned specifically with the question of what the average consumer is habituated to see in the market, and therefore how he approaches the meaning to be attributed to mark or bits of the mark.
Thank you.
Can I ask a question from a position of ignorance, Mr. Eden? Explain the proposition. Just to amplify the proposition that the CJEU has here. Why isn't it the case that the more distinctive a mark, the less likely it is that people are going to be confused about it?
My lord, I pause because my lord's point has caused some consternation within the profession from when it was first uttered that the more distinctive gives rise to greater scope of protection. There is a distinguished former member of your lordship's court, Lord Justice Jacob, who put forward exactly the proposition that you are now positing to me, that the more distinctive a mark, then the less readily should it be confused with something else, because one knew it so well, one was not therefore confused. That, though, is a line of jurisprudence that the Court of Justice has not followed, and therefore what your lordships are bound by at this stage is that the more distinctive something is, the more likely there exists the likelihood of confusion.
And the answer is it's normative, it's not empirical. And whether it's normatively justified is not for us to debate, because that's the law.
my Lord Justice Arnold has put it better.
Can you explain to me, I'm sure I ought to know this, what the status of CJEU decisions is for a case like this, which was started before we left the EU, but we're now hearing an appeal?
Thankfully, that's a relatively simple question.
I thought it was.
You're bound
We're bound.
by these old Court of Justice cases.
We're not bound by new Court of Justice.
Exactly, that's why I put that adjective in.
Yes. And why is that? Just in one sentence?
The withdrawal agreement.
Withdrawal agreement.
Yes. Thank you.
Anyway, let's move on. I'm sorry I diverted you.
No, not at all. It is a very live point in some senses, because there's been much debate about it and much writing. Now, moving on, you should be in in bundle C, I believe. If you remain within bundle C of the authorities bundles, the next case is the Levi Strauss case, which is tab 19. And I'd like to draw your Lordship's attentions to paragraphs 17 through to 20. The proprietor's rights to protection of his marks from infringement is neither genuine nor effective if account may not be taken of the perception of the public concerned at the time when the sign, the use of which infringes the mark in question, began to be used. So the point that we need to draw out from this is that the relevant moment is the time when the alleged infringer started their alleged infringement. And the court goes on to explain, if the likelihood of confusion were assessed at a time after the sign in question began to be used, the user of that sign might take undue advantage of his own unlawful behaviour by alleging that the product had become less renowned, a matter for which he himself was responsible, to which he himself contributed. So therefore, a defendant who is using an allegedly infringing sign cannot benefit by their alleged infringing activity because of their presence on the market, so to speak, diluting the distinctiveness, eroding the distinctiveness.
Well, I understand that, which is an EU equivalent to the principle that a person can't take advantage of their own wrong.
Yes.
I don't see why it necessarily follows that all we're interested in is the assessment at the time of first infringement. Suppose the proprietor has in fact allowed the infringing sign to be on the market for 10 years. You can only go back 6 years because of limitation. Why don't you assess the state of the market at that point? Why do you go back to the very first infringement?
Sorry, my lord, I'm not sure if I understood. When you said 10 years, do you want the date of assessment to be 10 years or 6 years for the limitation?
Well, this seems to suggest that you go back right back to the beginning, so you go back
Yes.
10 years.
Yes.
And I'm saying, why do you do that? If all you can now complain about is the use 6 years ago, why don't you look at it then?
Well, there's a series of first instance cases on that, 2 of which are mine and say different things. as was pointed out by some Anthony Mann subsequently.
Anyway, Mr. Edenborough, what's your submission? Which one of my Lord's arguments are you going to plump for? Or not?
Yes, I know. I am really between the rock and a hard place here.
Well,
but the point being is Mrs. Justice Bacon, in her first instance decision in Easy Cosmetics, has decided to follow Sir Anthony Mann's decision in the first Easy Live auction case, where he disagreed with Mrs. Justice Bacon in her first instance decision in Easy Office. The long and the short of all that is, as we get back to my Lord Justice Nugee's point, you go back 10 years, not to the limitation point,
Right.
because you must judge it at the point of first alleged wrongful use.
Right.
the Easy Cosmetics case to which I've just referred came out about a month or so ago.
Has there been, these are all first instance decisions?
Yes.
Yep.
It's now 2-1, so to speak. Sorry. Oh, I can give you the neutral citation.
This is Mrs. Justice Bacon's latest judgment, is it? You're giving us?
My Lord, yes. 2024, EWHC, 1441 Chancery. She discusses...
Well, yeah, but it all goes back to BDO,
Yes.
where that rule was first stated, and then it got misquoted in W3.
Yes. Have I answered all my Lordship's questions on that particular point?
Well, but the point is that none of those decisions are binding on us. So theoretically, we could decide something different, but it's not an issue on this appeal.
First, that's right, it's not an issue on this appeal. Second, the most recent decision of Mrs. Justice Bacon in Easy Cosmetic is not going to be appealed on that point. So it's not going to come before your Lordships on that issue, assuming it ever comes before your Lordships.
Okay, thank you.
Right. So, my Lord Justice Nugee, that was, I think, in response to paragraph 18 of
Yes.
that. I was then going to go to 19 and 20. Article 12.2a of the directive provides that a trademark is liable to revocation if, after the date on which it was registered in consequence of acts or inactivity of the proprietor, it has become the common name in the trade for a product or service in respect of which it's registered. So pause in there, excuse me. You need to note that the thing, the mark, has become the common name for something, and that has arisen because of the acts or inactivity of the proprietor. We continue. Thus, by balancing the interests of the proprietor against those of his competitors in the availability of signs, the legislator considered, in adopting this provision, that the loss of that mark's distinctive character can be relied on against the proprietor thereof only where that loss is due to his action or inaction. Therefore, as long as this is not the case, and particularly when the loss of the distinctive character is linked to the activity of a third party using a sign which infringes the mark, the proprietor must continue to enjoy protection. In the light of all the foregoing, the answer to the first and second questions must be that Article 5.1 of the directive must be interpreted as meaning that in order to determine the scope of protection of a trademark which has been lawfully acquired on the basis of its distinctive character, the National Court must take into account the perception of the public concerned at the time when the sign, the use of which infringes that mark, began to be used. So the points that I take from that are that the distinctiveness that you take into account when assessing the existence of the likelihood of confusion of the mark in question cannot be eroded or lessened or diminished in any shape or form by the infringing activity of the defendant.
So how do you square that with honest concurrent use?
Because the way in which honest concurrent use arises is due to a set of very peculiar facts that first of all don't arise in this case, and secondly require a re-education of the public at large, such that eventually one holds that there does not exist a likelihood of confusion between the allegedly infringing trademark and the honest concurrent user.
But one honest concurrent user may be the junior user, and so it may have started out as an infringer.
Yes, but it's so to speak, it is a special exception to the whole scenario, and it takes a peculiar set of facts, and eventually one has to make a binary decision between does there exist a likelihood of confusion or does there not exist a likelihood of confusion. The court cannot make a grey decision, and that is the artificiality of the exercise highlighted expressly by that example. Because until the court holds that honest concurrent use is operative, it's infringing use. And then from the moment that the court holds that honest concurrent use applies, it is not infringing use. And in that sense, the court's job is artificial and hypothetical. And you can't avoid that. Because as a court, you have to decide, is there or is there not infringement? My Lord, does that address the point sufficiently at this stage?
Yes, thank you.
Now, picking up a little bit upon this point about the the claimant's activity or inactivity, still within this case, if you go to paragraph 26, which you'll find on page 910, by its fourth question, the National Court is essentially asking whether it is appropriate to order cessation of the use of the sign in question if the trademark has lost its distinctive character wholly or in part after that sign has begun to be used, and that loss is due wholly or in part to an act or omission of the proprietor of that mark. So what we're looking at here is that the mark was properly registered to start with, so therefore cannot be invalidated. But subsequent to its registration, due to the acts or inactivities of the registered proprietor, the distinctiveness is now eroded sufficiently that it ought to be revoked because it is no longer distinctive. And this is picked up, if I may, in paragraphs 32 and 33, which are on the next page. It was recalled in paragraph 28 of this judgment that a trademark is liable to revocation if it has become, in consequence of the acts or inactivities of the proprietor, the common name in the trade for a product or service in respect of which it has been registered. Now, the point there is that what one is looking at in particular is for a word mark that has become to designate the product itself. An example would be pizza. At one stage, that might have been distinctive, but it's now become the common name in the trade for a particular type of product.
Chicago pizza is a better example.
Chicago pizza is a better example, as my learned friend has said, because Chicago pizza was a particular subtype of pizza, which at one stage I think was registered, wasn't it? Yeah. And is no longer capable of being distinctive in the hands of any particular trader. Right. And so you're looking at the name there. Now, to argue against myself, it is possible that you could have a sign that could become, in essence, something that is generic. But that, we say, is far more difficult. Because how does a sign become a generic indicator for goods or services? That fault, we say, is far more likely to occur for a word. But until, due to the acts or inactivities of the registered proprietor, that has happened, the mark is held to be distinctive. And you'll hark back to the fact, the pleading that I drew your attention to, paragraph 6L and 6N of the fourth and fifth defendants' defence is that they were seeking invalidation, not revocation. So the allegations that were put forward by the defendants at that stage don't even dovetail into this category of the mark purportedly losing its distinctive character over time, and such, because of the acts or inactivities of the registered proprietor, becoming non-distinctive. And you'll recall that I also drew your attention to the supplementary judgment, which was mainly concerned with the anti-suit injunction, which was all predicated upon the fact that the claimants were so active trying to pursue other people that there ought to be an injunction against them from bringing other cases. And so I plead that in aid in my case, that the claimant has not been inactive, such that its registered trademark has become the common name. And bearing in mind here, what the real allegation goes to is that the horse and rider motif has somehow become the common name of T-shirts. That's what it really boils down to. And I say that cannot be right. It's a confusion of two things. The distinctiveness of the mark for the goods for which it's registered, T-shirts in particular, and a confusion with respect to the fact that there's an allusion to a sport. That doesn't destroy its distinctiveness. Now, so far, this has focused upon the activities, the allegedly infringing activities of the defendant, the actual other party to a particular case. And I now wish to widen that, if I may, by going to the Attorney General's decision, again in the same case. And you'll find it behind tab 18, which is where you should be already. But this time at page 899, paragraph 40.
Advocate General.
Yes.
You said Attorney General.
My apologies. Advocate General. And so I accept that this is only the opinion and not the judgment. And so therefore I can only rely upon it as putting forward a proposition as opposed to in any shape or form binding your lordships. So, where the disappearance of the power to differentiate is caused by the activities of third-party competitors in the market, to deny the national court the opportunity of ordering the cessation of the use of signs, which is likely to have an adverse effect on a proprietor's use of his trademark, would be tantamount to encouraging those infringing undertakings to carry out concerted action to flood the market with similar signs and then claim that the logo they have imitated has weakened. In this context, I agree with the Commission that it will allow them to gain an advantage of their own unlawful acts.
Forgive me, I don't think you told us where you were reading from.
My apologies. It's page 899, paragraph 40, same tab.
Thank you.
It's the last paragraph. Right.
Yes, I have it. Yes.
You can see why I'm relying upon this, because the wording is more general. It's talking about...
But it's still looking at infringers.
Yes.
It's just infringers plural rather than infringers singular.
Yes. But from my point of view, my lord, that's a useful extension. Because what one has done here is one sued a particular defendant. Admittedly, there are 5 of them. But there are other people out there in the market. And that's how I'm building that argument. So that brings me to the end of the first part, which is the little Roman 1 part, which we say that the defendant's activity as a matter of law needs to be disregarded. And now I'm going to sway into the little Roman 2 part, which is where you look at the context, the relevant context, and things that are outside the relevant context should be disregarded. And to put that forward, I'd like to go, if I may, to the Planet Art case, which is in Bundle B of your authorities, tab 12. So Bundle B, tab 12, Planet Art case, and at page 644 and paragraphs 23 to 25 in particular. Now, I realise there's quite a lot here, but I am, if I may, going to read through it because I'd like to stress various bits as we read through. So, this is a decision of Mr. Daniel Alexander, whoops-a-daisy. Yes, QC at the time. Sitting as a deputy. 23, page 644. This leads to a related issue, namely the extent to which the whole context of a disputed use can be taken into account in determining the existence of likelihood of confusion. So to put that sentence in context, what you've got is allegedly infringing use. And of course, the allegedly infringing use doesn't exist in a vacuum in the commercial real world. But the judge now wants to look at what is the relevant context in which you must place that allegedly infringing use in order to ascertain whether or not it actually does infringe. As to this, it is necessary to exercise some care. That is an understatement. It is clear that a sign complained of must be evaluated in context in which it is actually used. And then he quotes what Lord Justice Kitchen said in Specsavers. These paragraphs were considered by Mr. Justice Arnold in the Hoch-Ziff case. The case concerned a claim by Hoch-Ziff that OCH Capital had infringed its community trademark registrations for the marks by the use of the OCH Capital sign. After referring to the paragraphs of the decision of the Court of Justice in the O2 case, set out above, he, that is, Mr. Justice Arnold, continued. The question which arises is this: how far do the context referred to by the court and the circumstances characterising that use referred to by the court extend? Counsel submitted that the context and circumstances were limited to the actual context and circumstances of the use of the sign itself. Thus, in the O2 case itself, where the sign was used in a comparative advertisement, the context was the whole of the comparative advertisement, but no more. In contrast, counsel for the defendants submitted that the context and circumstances included all the circumstances relevant to the effect of the use of the sign, including circumstances prior to, simultaneous with, and subsequent to the use of the sign. In my judgment, the context and circumstances are limited to the actual context and circumstances of the use of the sign itself. The Court of Justice expressly said that at 64, and the referring court was right to limit its analysis to the context in which the sign was used. Furthermore, it referred at 67 to the circumstances characterising the use, not to circumstances more generally. Thus, circumstances prior to, simultaneous with, and subsequent to the use of the sign may be relevant to a claim for passing off, or, under other legal systems, unfair competition, but they are not generally relevant to a claim for trademark infringement under Article 9(1)(b). In saying this, I do not intend to express any view on the question of post-sale confusion. That's a matter which we're going to deal with later. Then we're going back to now what Lord Justice Kitchen said. It's not entirely clear to me what Mr. Justice Arnold and the parties had in mind by the phrase circumstances prior to, simultaneous with, and subsequent to the use of the sign, but it must, I think, be seen in light of the particular and rather specific issue of that case, namely whether Article 1 will be extended to the confusion arising from the use of the sign in advertising and promotional materials, so-called initial interest confusion, whether or not any sale resulted in and whether or not the consumer remained confused at the time of any such sale. Now, dropping down to paragraph 24, in my view, Mr. Justice Arnold was saying that the CJEU took the view that in considering infringement of a registered trademark, it was not appropriate to look so broadly at the context that use, which was prima facie infringing, was nonetheless to be regarded as non-infringing because other separate acts of the defendant had countered actual deception. And then we have an extreme example is where a defendant uses a well-known brand for counterfeiting goods, but nonetheless makes it very clear that the goods are in fact counterfeit, and so that no actual purchaser is confused. There may be no actual confusion as a result of the use of the sign, but there is nevertheless trademark infringement because the court must focus on the use of the sign in question and not the other statements by the defendant as to the trade origin of the goods. And then paragraph 25, accordingly, while it is right to take the context in which the given sign will be seen into account, I'm not persuaded that it would be right to expand the view so broadly as to take account of the fact that a given sign only appears in this case after a different sign has been used. To that extent, each use of the signs must be examined separately in what might be described as its local context.
So what do you say is the upshot? Because certainly one view is that the Court of Appeal in Specsavers said that the contrast that was drawn in Opposite was wrong, and in particular that it was wrong to limit the inquiry to the actual context and circumstances of the use of the sign. And yet Mr. Alexander QC seems to have followed Opposite, which it wasn't open to him to do since Specsavers was binding on him.
My Lord, the way in which I am going to endeavour to square that circle, mathematically impossible as it might be, is that it goes back to this point, if I may, with respect to the honest concurrent user point. There are things that occur in the marketplace which may or may not have an effect upon the actual, real, live, flesh and blood purchaser. But the exercise that your lordships have to conduct and the poor trial judge has to conduct is to some extent a hypothetical exercise that is removed in some cases and in some parts from reality.
This is all very theoretical. Could you give some examples to help
Yes,
the struggling amateur?
I'm coming to that, if you see what I mean, my lord, because I was then going to focus down on the honest concurrent use.
Yeah.
Honest concurrent use happens as a continuous thing. And then at one point, it suddenly flips over to becoming a defence, such that the court will then say there is no confusion. But in reality, there is no magic watershed moment. It's a continuum. But the court has to impose a watershed. And the same thing here applies. If you have a consumer that goes to a market stall, and above the market stall it says in big letters, everything sold here is counterfeit. And then you see, for example, a scarf were in a stall outside the Arsenal
The
stadium.
Arsenal football ground.
Yeah, but the answer to that is easy, and it's the answer that the Court of Justice gave in Arsenal and Reed, namely it's post-sale confusion. So actually it doesn't give you an answer to the question, where does the context start and where does the context stop, because you solve the problem in a different way.
Yes and no, my lord. In Arsenal, you can say there's post-sale confusion, and therefore, because the sign is not present post-sale.
The sign is present, the distinguishing matter isn't present.
Yes. But the reason why it's still relevant to what I'm going to say is that at the point of sale, there is no operative deception and therefore no passing off. Because what I'm going to try and draw on one hand is the issues of trademark infringement, where you're protecting a monopoly right, and a common law cause of action, which is completely focused upon what actually happens in the marketplace.
Well, can you give another example that doesn't engage post-sale confusion, of how the context flips, to use your phrase?
In the case in Planet Art, there was a use of another sign before you came to the allegedly infringing sign. And so therefore, Mr. Alexander was trying to say that you couldn't take into account that previous earlier use of that other sign. That's what he's saying in paragraph 25. The fact that a given sign only appears in this case after a different sign has been used.
But can I come back to the question I put to you, and let me be clear as to the question I'm putting, because I understand you submit that OXIF is correct, and you also submit that Planet Art is correct. But the question I'm putting to you is that submission open to you as a matter of law, having regard to the decision of this court in Specsavers?
Well, my lord, the reason I'm hesitating is because I might ask you to narrow the question down in the sense of which particular bit of Planet Art and OXIF are you saying is incompatible? Because there are definitely bits in...
Well, an alternative reading is that actually Specsavers is a fudge, and a deliberate fudge, and it doesn't answer the question.
Yes.
But is that your submission?
Yeah. Thank you, my lord. The short answer to your lordship's question is yes, it is a fudge, because when Specsavers went back to the Court of Appeal after the Court of Justice, it was dealing with the issue of non-use, not infringement. And therefore, what was read in the context of non-use has then been cross-fertilised over into the earlier issues of confusion. And so there is a certain, I dare hesitate to say this, but smoke and mirrors with respect to that second Court of Appeal decision. So I am not working with perfect material here. So I realise that's a very dangerous statement given the material with which I'm working, but my lord, I'm trying to put forward a proposition that there is a fundamental difference between trademark infringement and the common law tort of passing off. The common law tort of passing off is you take into account actually what happens in the real marketplace. It is a common law tort of operative misrepresentation. So therefore, if there's a sign above the stall that says these are all fake, you're not deceived, therefore there's no misrepresentation, therefore no passing off. But in trademarks, because it's a monopoly right that the state has conferred upon the registered proprietor, that the way in which you then round that monopoly right, square that monopoly right with the interests of competitors, is that you engage in a slightly artificial exercise when you do the analysis of does there exist a likelihood of confusion. And one of the ways in which you do that is you ignore the activities of the allegedly infringing defendant because a wrongdoer can't benefit from their wrongdoing. But you also focus down upon the relevant context. And the relevant context is relatively narrow. It is focused upon the particularly allegedly infringing wrong activity under examination. And you don't bring into that the things that happen before or after, or maybe contaminating the pool while you're still quite narrowly focused. Does that get anywhere near answering my lordship's
I think it's as good as an answer as can be given in the circumstances.
Oh,
So shall we move on?
In which case,
That's
I'm
a
gonna
pass.
definitely
That's a
stop.
pass.
Yeah, I'm definitely going to stop there, my lord.
Yes. Right. So where did we have we finished with Specsavers or Planet Art rather?
The answer
I mean, it's
is...
quite odd, isn't it, that this is all looked through the prism of this first instance decision by the deputy judge.
well, it's partly because Mr. Dan Alexander has gathered together a lot of authorities together in one place. So
Yeah.
it's a useful... Otherwise, I'd have to chop and change to different authorities. I was going to move on from Planet Art, if I may, even though there's one further quote from that, but I'll come back to that in a moment. And that is, it has been said, and this is relevant to a point that our Lord Justice Arnold has raised, but this time only in passing, is that so far I've mentioned really quite expressly Ralph Lauren and the USPA, US Polo Association, and I've shown you their logos. And one, the Ralph Lauren one, is the horse and rider coming straight towards you, and the other one, the USPA, is that the two horses are quite different. But the whole point about this case is there are a number of other logos which are side on, which is like the mark and sign in this case. The Beverly Hills one is with the horse cantering off to one side, but it's a side-on profile with the horse and rider. And the allegedly infringing sign, in particular sign 3, it's the same sort of thing, even though it's only...
Different direction.
Yeah, different direction.
Different colour horse.
That I'm not so sure about. Different direction.
Mallet is held in the other hand. Not the whole horse visible.
My lord, in polo, the mallet has to be held in the right hand. So if it's held in the other hand, it must be an incorrect representation. That's one of the rules of polo. I had to check that at an earlier point.
Is that relevant?
No, but if you were going to draw a distinction between left and right hand, then it would be relevant.
Well, we're looking at the mark, aren't we?
Yes.
We're not looking at rules of polo.
But the point being is here, we say, and this is, that there's a lot of third-party activity there of signs out there by other side-on representations of a horse and rider. And it's been put forward that these third parties do not infringe. Well, that's not common ground between the parties at all. What it is that we haven't sued any of them, but it's not common ground that they don't infringe. Now, might I take you to the Jack Wills case? You'll find this in Bundle A of your authorities, tab 5. So Bundle A authorities, tab 5, and I'd like, if I may, go to paragraph 87. This is on page 281. And this is under the heading of distinctiveness of the trademarks. Counsel for Jack Wills submitted that the trademarks were inherently very distinctive. That's what I'm doing. Counsel for House of Fraser did not suggest that the trademarks were devoid of distinctive character. His primary submission was that the trademarks and the pigeon logo were distinctively different from each other. I should consider that question below. In the alternative, he submitted that if the differences between the trademarks and the pigeon logo did not suffice to enable the average consumer to distinguish between them, then it follows that the trademarks were insufficiently different from other bird logos to possess distinctive character. I do not accept this argument. Now, you'll recall that that echoes the allegation that was put forward by the fourth and fifth defendants at paragraph 6L of their defence. And so that argument has been rejected. Leaving aside the fact that it ignores the differences between the dates at which the validity of the trademarks and the issue of infringement fall to be assessed, the pigeon logo is closer to the trademarks than the trademarks are to any other bird logo of which there is evidence of use in the UK. Taking account of the other bird logos for which there is evidence of use, I consider that the trademarks have a substantial degree of inherent distinctive character. An important factor in the distinctive character of the trademarks is their anthropomorphic aspect, and in particular the fact that the bird is equipped with accessories associated with an English gentleman. Now, in this case, we say that by parity of argument, you can see that with respect to the Ralph Lauren logo, that's a logo of the riders riding towards you. That's quite clearly of one type of logo. The USPA logo is of two riders. Again, that's a different type of logo. And then we have side-on logos. And so here we say, again, there's quite a different group of logos that are out there. And so therefore, you can't, so to speak, affect the distinctive character of the Beverly Hills logo mark because of the presence on the market of the Ralph Lauren logo or the USPA logo, because they're quite different. So those uses are non-infringing uses. I'll come more to that in a moment. But if they're non-infringing uses, they don't bear upon the distinctive character of the Beverly Hills mark. And so therefore, that is an aspect that really is outside of the context that you need to look at.
Distinctiveness is not a binary concept. You can be more or less distinctive.
My lord, there's two parts of the answer to that question. The first point is that once you have crossed the threshold and achieved a certain level of distinctiveness, you are distinctive. But then once you cross the threshold, you may become more distinctive.
Yes. But I have not understood. I'm sorry, it's my fault.
No.
Your argument about the crowded marketplace, I thought it was an argument of principle, that you don't look at what else is in the marketplace, because you just look at your mark and it's distinctive. And that's the beginning and end of the question.
Yes.
But the submission you've just made seems not to be addressing that point, but addressing how similar Ralph Lauren and USPA are to yours.
Yes, I'm persuading the argument.
Which is a different point, isn't it?
Well, the way in which I'm swaging it is that, as a matter of principle, I say you should not look at them.
Well,
then,
yeah,
sorry.
Yes, I have not quite understood why not, because in Jack Wills there were half a dozen other clothing manufacturers that did use birds, but the point was when you looked at them, none of them had this anthropomorphization with the top hat and so on. So it wasn't a question of saying you can't look at them, but you could look at them and see how close they are. And whereas I thought your submission on Grand Marnier was you can't look at them.
Well, no, you're right, my lord. I'm saying you can't look at them.
Oh, now, why not?
But because you shouldn't look at things. First, you shouldn't look at allegedly infringing activity. I'll come back to that in a minute. Secondly, you should look at the right context. And third-party use falls out of the right context. Then coming to the particular point you just raised with me, Ralph Lauren and USPA, you don't look at anyway because they're too far away. They can't bear upon the context. But this is one of the cases that's being used against me, and that's why I'm raising it.
Well, I would have thought this was an illustration of the proposition, but in assessing how distinctive the mark is, you can have regard to whether there are other marks in the marketplace of the same type, depending on the facts, depending on how closely similar they are or not. Because if your submission was right, it should have been irrelevant that there were other clothing manufacturers who used birds, whereas what my lord actually did is look at the birds and say, well, they're not of the same type as Jack Wills's and House of Fraser's birds.
My lord, yes, this moves into my third part of the first limb, if you see what I mean, which is that on the facts that you there are certain things that you should and should not look at.
Yeah.
So I'm probably...
Yes.
I have a slide-in position, and I have an absolutist position. You just shouldn't look at anything.
You should just look at the mark.
And the allegedly infringing side.
And so just compare those two.
Yes.
Well, it's that which I think this case is a counterexample to.
Yes.
And I have not understood what's wrong with looking at what else. When you're as my lord debated with you earlier, the CJU said the more distinctive, the greater the area of protection.
Yes.
So the easier it is to find likelihood of confusion.
Yes.
The converse of that, which I understood you to accept, is that the less distinctive, the smaller the area of protection, the more difficult it is to find likelihood of confusion.
Yes.
And I would have thought, as a matter of logic, unless you explain why it's wrong as a matter of law, but as a matter of logic, if there are lots of horse and rider logos in the market, having a horse and rider logo becomes less distinctive from what you have to do, which is what you've just been doing, is say, oh, but ours is different because it's side on and theirs is face on. But that's not the same exercise as simply saying you just ignore the fact that there's Ralph Lauren, USPA and other people in the market. And I've not quite understood why you just ignore that fact without looking at how close, how similar or not they are.
Yes. My lord, the way in which I'm going to endeavour to answer your point is that when I'm talking about, hypothetically, when you say a mark is more distinctive, therefore the existence of likelihood of confusion is more likely, and the flip side of that is the less distinctive it is, the less likely it is to find the existence of likelihood of confusion. When you're looking at that point, what you need to do in my submission is to only affect the distinctiveness of the allegedly infringing sign by consideration of certain things. Because I say that these marks, my mark, the Beverly Hills mark, is distinctive for clothes per se, because there's no allusion to clothes with respect to the polo and rider motif. So it's a distinctive mark. The argument used against me is that that distinctiveness is eroded. And I say, as a matter of law, you should not look at the allegedly infringing activity with respect to the defendant sign 3.
Well, that I think is established.
Yeah.
Yes.
I also say that you should not look at the allegedly infringing activity of other similar marks.
Again, that I understand.
That I get support from that from the AGs.
Yes.
Yeah. Then I say, as another way into this, that the way in which you conduct the exercise is by focusing down on a particular local context, hence my reference to Planet Art, my reliance upon that. The local context being the interplay between the allegedly infringing mark and the allegedly infringed mark. So that way I can, I say, remove the influence of third-party activity. Now this...
But that's a question of context, and I understand there is a question about context.
Yes.
You distinguish in your grounds of appeal between distinctiveness, between the existence of logos, of horse and rider logos, insofar as it goes to distinctiveness and insofar as it goes to context. Now, I understand the submission in relation to context, but I don't understand why that gives you the answer to the question on distinctiveness, because it's implicit or explicit in what the CJAU has told us. Some marks are more distinctive than others. It's not. That's why I started this by saying it's not just a binary question.
Yeah.
Some marks are more distinctive, some marks are less distinctive.
Yeah.
Now, I would have thought a less distinctive mark was one which didn't stand out from other marks in that field.
But the way in which I'm trying to answer the Lordship's question is that when you consider which other marks you should consider in that field, I say that you should remove the influence that other allegedly infringing marks would have.
I understand that, but Ralph Lauren is not, and USPA are not allegedly infringing marks.
No.
So why can't you look at that? That's what I'm having difficulty with.
Well, sorry. I think the confusion is created entirely by my submissions, my lord. The point being is that you do not look at Ralph Lauren because it is so far different. It cannot have an effect upon the distinctive character of the.
But that's not a submission in principle. That you can't look at other horse and rider marks in the market, which is what I understood you to be saying.
Yes.
It's a submission on the facts that when you do look at other horse and rider marks, they're so different they don't have any diluting effect on yours.
Yes, my lord. Sorry. This moves into my third ground. That.
Well, I understand that, but I'm trying to tease out your first ground,
Yes.
which is you can't look at Ralph Lauren and USPA at all, if I've understood it.
Yes.
Why not?
Well, you can't look at them because they have no relevance. But maybe that's a circular argument.
But that's on. You say on the facts, then they're not similar.
Yes.
Suppose they were more similar. Suppose Ralph Lauren was side on. Could you look at it? I mean,
Well, then I would say no, you couldn't, because it'd be a third party allegedly infringing sign.
but it's a senior user to you. How it couldn't possibly be infringing your sign, could it?
Well, that's a more complicated question. Just because I'm the junior user. My lord, we're
Okay,
actually,
I think I've
Yeah.
asked my
Yeah.
question.
Sorry, I haven't answered it directly, but just because you're the junior user doesn't mean there could be other reasons why there might be still a conflict. But thankfully, that particular scenario does not turn up here.
Yeah.
Lord Justice Baker, were you about to say something? No.
No, I was I was thinking of saying, shall we move on to the next point?
Yes. Thank you.
Because the Lord said he's answered his own question, so I think that's, if I were you, I'd move on to your next.
Yes. The reason I'm referring to this case is because it's been cited against
Yes.
me. So it might not fit most logically into this particular part, but I do have to distinguish it. And the factual matrix there was
you
that...
don't. You can say it's wrong.
Sorry, my lord.
You can say it's wrong.
Actually, you want to embrace it because
Yeah,
it's a case where infringement was found.
I'm embracing it, my lord.
He's embracing it. Yes.
But having said that, I'm about to say that the next case has a question mark over it. And that is the Greenwich Polo case. You can find this in your authoritative bundle B, tab 13. And if you go to page 713, you can then see the mark on the side. But the relevant bit to which I'd like to draw your attention is paragraph 1, which is on page 741. Now, no infringement was found in this case, and I've shown you the signs on page 713. But one of the reasons why no infringement was found, can be found in the analysis of the judge, paragraph 51. In particular, subparagraph 1. The figurative elements are different. I should say at the outset that I regard the figurative part of both the logo and Greenwich sign as the least significant element of these marks. The fact is that the rider or riders on a polo horse or horses with polo mallet or mallets does not do anything more than evoke the sport of polo. This is not a case of the Nike swoosh or some other purely figurative sign that links to or evokes a particular brand or producer. And it goes on at the bottom of that paragraph. Mr. Durbridge makes clear in his evidence many brands, clubs or entities deploy the polo horse and rider motif in their branding, but always with additional word elements to designate club, origin or brand. The claimants object to this evidence on the grounds that all that was in issue was the similarity or otherwise between the logo and Greenwich sign 3 and the resultant risk of confusion to consumers. That, of course, is right, but irrelevant. Well, I say it's actually critically relevant. And then the judge continues, the point being made by the defendants was that the polo horse and rider motif was generic as a reference to the sport in general and not to any particular brand. Well, my lords, I say that that's the wrong analysis, because what has been confused there is that polo horse and rider motifs cannot be generic in a distinctiveness sense with respect to the trademark for clothing. They're not generic for clothing, they're distinctive for clothing. What has been confused here is that more than one trader uses those motifs that relate to the sport. But that's pretty much irrelevant to...
Why is that irrelevant?
Because when you're assessing the existence of the likelihood of confusion, one of the relevant points is the similarity or otherwise of the goods. They're identical here. But also, as I've shown you, how distinctive is the sign?
Well, how distinctive is the mark?
The mark.
Yes.
And what the judge here is doing is diminishing the distinctiveness of the mark. We say by false reasoning.
What's false about it? He says there are lots of other horse and rider.
But he's saying that it's generic with respect to the sport.
By reference as a reference to the sport in general, not to any particular brand.
So that seems to be true.
Well, but it's irrelevant. These marks are distinctive for clothing.
But
They're not. Sorry.
I mean, that would suggest that you were saying, because I use a horse and rider, evoking the sport of polo for my branding, nobody else can use a horse and rider evoking the sport of polo for their branding.
No, my lord. The point is that the mark is registered, so therefore the various intellectual property offices have decided that the mark is distinct.
Yes.
And what you see on the marketplace is that there are a number of different logos out there. What I'm trying to draw to your attention is that the Ralph Lauren one, for example, is quite different from the USPA one, which is quite different from the Beverly Hills one. And so therefore, the influence of those two cannot diminish the distinctiveness of the Beverly Hills logo for the goods for which it's registered, namely shirts. And the mere fact that there are horse motifs out there, horse and rider motifs out there, which might refer to the sport of polo, does not have a relevant bearing upon the distinctiveness of those marks for clothing. That's the distinctiveness that you need to take into account when you're assessing the existence of the likelihood of confusion. And I get to that route by the various different ways I'm saying that you need to look at the relevant context.
Okay. Have these comments of Mr. Justice Marcus Smith been considered?
Permission to appeal in that case was refused. So
not on that. Have they been considered in any subsequent case?
The judgment under appeal.
I think just this.
Apart from
Then no. This is we would say an outlier. My learned friend says no. But
are you going to show us how the judge dealt with this authority? What the judge in our case, as Justice Mellor, said about this decision? Come back to that.
Yeah, I'll come back to that a little. Well, the long and short of it is he aligns himself with it.
But you say that this is wrong.
Yes, but because not necessarily on the facts, because I showed you the signs at page 713, but the way in which he is discussing the issue of distinctiveness is a false analysis.
That's why I ask about how the judge dealt with
Yes.
it. Because if Mr. Justice Marcus Smith was right on the facts, your complaint is not so much about the proposition, but the way it's been adopted in this case.
But we see, we say that again, it's the wrong thing to look at. That you look at whether or not the motifs might be elusive to the sport. That's not the criteria by which you are judging the distinctiveness of the marks. You need to judge the distinctiveness of the marks whether or not they're elusive to the goods in question, which is T-shirts. And they're not distinct, they're not elusive of any characteristic of T-shirts. These are not shirts for playing polo. They're not that sport related. These are just clothing items. So therefore there's no proper delineation of the distinctiveness that you could take into account because they refer to polo.
The proposition you're challenging is the last sentences below the indented passage on 742. The polo horse and rider motif, on the evidence I have seen, adds nothing to the distinctiveness of the logo, save to make it clear that there is a generic link to polo and to sport.
Yeah.
So that's wrong.
Yeah.
Although it was on the evidence he'd seen. Right. Have we finished with the Greenwich case?
Yes. And my lord, I've already mentioned all of this, but it's brought to head in the Planet Art case. I can probably just give you the reference, which is Planet Art, paragraph 164, which is on page 682 of Bundle B. This is where Mr. Daniel Alexander draws a distinction between trademark infringement and passing off, which is what I've been trying to draw as well. And that's just crystallised there. So then we move on to a completely distinct point, and that is if you are against me and that you should take into account third-party activities and they're not excluded as a matter of law, or they're not excluded because they're not part of the relevant context, then under my third limb of my ground to appeal, paragraph 1A, we say that on the facts of this case, it was not proven that there was a relevant body of people who were unaware of the crowded market. So what I need to show here is that on the facts of this case, the crowded market argument succeeds. Now, the way in which I'm going to put this is that you can only take into account the effect of third parties if there is no significant number of average consumers who are unaware of the crowded market. And because that has a double negative in it, to try and express it maybe not quite so precisely, but maybe more clearly, the point being is that the defendants have to show that nearly everybody is aware of the crowded market. Or another way of putting it is that there are only a de minimis number of ignorant consumers. Now, in order to deal with this, the first thing you have to look at is the average consumer. And the first point here is that the average consumer is not some homogeneous mathematical average. The average consumer are really the average consumers who occupy the middle portion of any distribution curve. And the reason for that is you want to get rid of the people who are particularly ignorant and who are particularly knowledgeable. So people who fall at either end of the spectrum, you remove. But still within the middle tranche, there are people who have a range of different perceptions, different knowledge, and what have you. And to support that proposition, might I go to Authorities Bundle C, the Musmat case. And this time, paragraph 31, which is on page 781. So what I'm focusing here is the properties of the average consumer. The judge stated that the test for infringement under both section 10.2, 10.3 was to be conducted through the eyes of the hypothetical person referred to as the average consumer. It's correct that infringement must be assessed from the perspective of the average consumer of the relevant goods, who is deemed to be reasonably well informed and reasonably observant and circumspect. But the notion of a hypothetical person, while supported by authority, must be treated with care. The point of assessment from the perspective of the average consumer is that one excludes from consideration those who are either ignorant or who have specialist knowledge, and those who are either careless or excessively careful. But otherwise, one takes into account the characteristic of the relevant class of consumers. Such consumers are not an undifferentiated mass, but have the spread of relevant characteristics that human beings have. Moreover, it is sufficient to establish a likelihood of confusion that is a significant proportion of the relevant class of consumers is likely to be confused, even if many would not be. So the point being there is that you have the average consumer is occupying the central part of the distribution curve. You exclude the ignorant and the particularly knowledgeable, but within that middle part there is a range of possibilities. And when you are assessing the existence of the likelihood of confusion, it might be that a cohort within that middle part is confused. And if that is the case, then that is sufficient to find that there exists a likelihood of confusion. The Interflora case is at bundle B, tab 8, and it's paragraph 129, page 459. This, I only really need to take you to the last sentence of paragraph 129. If to the contrary, if, having regard to the perceptions and expectations of the average consumer, the court concludes that a significant proportion of the relevant public is likely to be confused, such as to warrant the intervention of the court, then we believe it may properly find infringement. So the point there that I'm drawing out is you don't need everybody to be confused, you just need a significant proportion. And in the same case, at paragraph 125, which is on page 456, this discusses the issue of, with respect to those average consumers and different cohorts within that central part, some are going to perceive the mark as more distinctive than others. Then you can see that at the last sentence, it necessarily follows that the court must therefore have regard to the impact of the accused sign on the proportion of consumers to whom the mark is particularly distinctive. And so what one has here is you have a range of people who occupy the central ground, so therefore they're all members of the average consumer. There are different cohorts within that central ground, to some of whom the claimant's mark is distinctive, and to some of whom it's less distinctive because of the presence of third parties. And this brings us into the discussion of the evidence. It's clear that Ralph Lauren and USPA are big players. And maybe this addresses my Lord Justice Nugee's point, or when I was talking about Jack Wills and Greenwich Polo. But it might be better to refer to those cases under this section, because it relates to the factual situation that, yes, Ralph Lauren and USPA are big players and therefore might have a bearing upon the perception of the average consumer. But those two players were much larger than either the defendants or the claimants. And they were probably third or fourth in the market in size. But with respect to the other signs, the other side-on signs, the evidence was really very, very poor indeed. There was no detailed evidence about those other side-on signs. When they started, how great their geographical extent was, the volume of sales, or when they came onto the market or not. And so therefore we say it's unsound to reach the conclusion that there is no significant cohort of people who are unaware of all of those side-on examples. They might be aware of Ralph Lauren, but that doesn't worry me because it's coming towards you. They might be aware and/or of the USPA, but that doesn't worry me because that's a multiplicity of horses. but there's no proper evidence to say that there's no significant cohort of people who were unaware of all these side-on examples. And all I need is for there to be a cohort that properly sits within the middle of the distribution curve, or somewhere in the distribution curve, not at the extremes, who are unaware of these side-on examples. And so for that cohort, the Beverly Hills mark has not been diminished in any shape or form with respect to its distinctiveness. And therefore, when you take that into account, there does exist, we say, an existence of likelihood of confusion between the Beverly Hills side-on mark and the defendant's side-on mark. And even if that cohort is aware of Ralph Lauren, horse running towards you, and or USPA, two horses running around, that does not diminish the effective distinctiveness of the Beverly Hills mark when you try and assess the existence of the likelihood of confusion in the local context of Beverly Hills and the defendant.
Are you going to address us about the words used in these marks, or are we to set that to one side completely?
Not set it to one side completely, but the law and the way in which you assess these marks is as a whole.
Yes.
And
what do you say to the proposition that there is a striking contrast between Beverly Hills and the Royal Berkshire?
well, we say
The words.
yes. The judge himself, at paragraph 268 on page 127 behind tab 6.
Right. Just let's put the authorities away for a moment.
Yes.
And go to the judgment.
Core bundle, tab 6, page 127.
Yes. Yes.
This is where he says in the last sentence, the second element comprises the words Royal County of Berkshire in the particular italicized script, which is more difficult to read, with the third element Polo Club in block capitals at the foot. So the comparison that you have to make is between the mark and the sign as a whole.
Yes.
And to answer your Lordship's question, we say that the words Royal County have a diminished effect because of their difficulty, the difficulty in reading them because of the italicized script. So you can't ignore them, but it's not determinative. And in Greenwich, the Greenwich case, to which I drew your attention, the judge there focused upon the words only because he was reducing the impact of the graphic element, we say wrongly. And if you look at the graphic element, we say there is similarity between the side-on representation of the horse and rider
You look at the whole thing overall.
Yes, my lord. You're looking at one of the pictures, presumably in the judgment.
Well, I'm
Page 17.
flicking between 127, the passage you've
Yeah, and
cited in the judgment, and
Page
page 70.
Yeah. So what you have there, I mean, you have the commonality of the words Polo Club, but you also have the commonality of a side-on rider, horse and rider. And in this case, remember, I'm now assuming against me that you take into account people like Ralph Lauren, USPA, because it's accepted that those two parties had a presence upon the market which would have some influence upon the perception of the relevant consumer. But the relevant consumer, when perceiving Ralph Lauren, would perceive a mark coming towards you, a horse and rider coming towards you, USPA, multiple horses, two horses in that particular case. And this is the third category of side-on representation. And in the real world, as the judge pointed out at paragraph 268, the italicized script, while pretty, is not necessarily, well, it's not as readable as the Polo Club representation works.
Well, more difficult to read, is what
Yeah,
you're saying.
yeah. So you cannot eliminate it. That would be wrong. But its distinguishing function is reduced.
Do you take issue with what he says in 269, where he lists the things that are similar and the things that aren't similar?
Well, actually, my lord, yes, for the following reasons. Direction of movement. My lord, that is a statement in my submission that you get when you compare the marks on page 70 side by side. I asked rhetorically, with respect to the man in the Johnny Walker advert for whiskey, is the man walking to the left or right?
But that is, I understand that when you're assessing likelihood of confusion, people have an imperfect recollection of things like that. But here he's looking at similarity. You can't assess similarity except by looking at them side by side, can you?
My lord, yes and no. Yes, you are absolutely right that if you want to enumerate the particular differences and similarities, you need to sit down with one on your left, one on your right, and look at them. It's like the match the difference pictures you get in magazines. But differences such as one goes to the left and one goes to the right is a difference you would spot side by side.
But you'd ignore it when you come to likelihood of confusion.
Yes. Because of imperfect recollection,
Yes.
I support that argument by the Johnny Walker example. Yeah. I had to learn which way ours goes. Ours goes to the right. I hope.
You were right about the mallet, by the way. They're both holding them in the right hand. I stand corrected.
Ah, yes, thank for the yes. I had to look that point up, my lord. So you don't cross mallets when you meet, if you see what I mean.
By reference to the sport, I see. Yeah.
Yeah.
Right. So.
And the impression, we would say, that you would take away is a side-on horse and rider swinging a mallet. The details, because you can actually see in the lower one on page 70, the shaft of the mallet is curved, whereas in the one above is straight.
Yep.
I mean, those are details which my lord Nugee you'd spot and delineate. But it's not something you'd necessarily recall.
No.
But what the impression is a rider leaning over the neck of a horse. There might be a technical difference between whether they're galloping or cantering. But there's an impression of speed chasing after a ball, side on. Whereas the Ralph Lauren impression is a rider riding towards you. USPA is two riders.
The point I was making, though, was whether it's right to look at the, and you can see it's not right, to look at the image in isolation. You look at the words as well.
Yes.
So, doesn't that add to the, or detract from the similarity and
Yes.
or add to the distinction?
Yes.
If you're just talking about, obviously there are things that are happening the same in these two images. There's a horse and a rider,
I can't
and
say.
a mallet,
Sorry.
and they're riding at some speed.
But the point being is, remember in the Jack Wills case, there was a point that was said that the trademark and the allegedly infringing sign were closer to each other than the trademark and the other things out there. And that's what I'm saying here. I'm not denying the existence of Ralph Lauren or USPA. Those might well have an effect.
So but it's not enough, is it, for it to be closer to Beverly Hills?
It has to cross the line.
It has to cross a line.
Yes. And I say it does because the line is between horse running towards you, multiple horses, side-on horses. And that's why I say that the Beverly Hills mark is closer to the defendant's allegedly infringing sign, in particular sign 3, because that's what we're focusing upon here, than if there be a clear distinction between Beverly Hills and Ralph Lauren and Beverly Hills and USPA. But here, this occupied middle ground is the ground that Beverly Hills has the right to monopolise.
I'm going back to my point about the words. I don't want to take up too much time on this, but they're not just words added to an image, are they? They're the way the words are drawn, written, ties into the image, doesn't it?
Yes.
In the Berkshire, you have a curvy font, as it were, which the font fits the image.
My lord, yes. I mean, that's all part of the skill of a graphic designer.
Yes.
But the whole thing sings harmoniously.
Yeah, okay.
I mean, that weighs in the balance. I'm not going to deny that. And it's all part and parcel of the impressions that you have to make.
But to get home, you have to satisfy the court, do you, that the features you've identified as being standout features, the sideway movement, the sideway image of the rider and horse, the fact that it's a horse at speed, swinging the mallet, that those override any other differences.
Coupled with the fact
That crosses the line.
identicality of goods, that's a big factor in my favour. And that these signs and the trademark is distinctive for the goods in question.
Thank you.
It's all a multifactorial analysis.
Yes.
But we say the judge erred in principle. That's why I'm allowed to come before your lordship.
Yes. Right.
And one of the ways in which this is put against me is that we're saying that all I need is a cohort that rightly occupies the central part of the distribution, that is unaware of these other third-party side-on logos. And it said, well, I can't do that because such people are ignorant and therefore should be excluded from the assessment because they're ignorant of these third parties. Well, I say that's actually a circular argument because what they want to do is that they say that only those people who are knowledgeable enough should be part of the relevant consumers. And they have to say, they have to prove that there's no relevant cohort that is unaware.
Why is the onus of proof on that? It's for you to show likelihood of confusion.
Yes.
So it's for you to show that the average consumer would be confused. And we know from the cases that simply means you need to show there's a substantial proportion of the relevant.
Yes.
But why is it not for you to show there's a substantial proportion of people who didn't know about other?
Because I'm trying to prove a negative, so therefore the evidential burden here is that defendants are raising as a defence. So it's an evidential as opposed to legal issue.
I see.
You got yeah.
Okay.
And we say the evidence just simply doesn't go that far. Evidence with respect to Ralph Lauren, we accept. Evidence with respect to USPA, we accept. But we're not fussed by that. evidence with respect to all these others, we are fussed, and we say it's not good enough. That's a 3-line summary, my lord.
Yes, I understood.
And actually, that probably deals with the way in which I should have dealt with Jack Wills and Greenwich Polo. It was more of a factual analysis. It probably fits better into this than trying to defend, which turned out to be indefensible, my legal line in the sand. But there's still 2 good legal points there, which is, as a matter of law, you should ignore them, and in any event, the legal point is the local context. My lords, I was going to deal with, if I may, the coexistence agreements.
Yes.
And then post-sale confusion. I could possibly do this before 1 o'clock.
Well, let's see how we go.
Yes, exactly. So, under my first round of appeal, there is, under section 1b, this issue of coexistence agreements. We can take it very simply and very quickly. If you go to the Authorities Bundle, Bundle C, tab 20, and it's paragraph 49 of the decision on page 921. Now, what we say is that this case actually does support the proposition that coexistence agreements as a matter of law should be disregarded. And we say that must be right because in paragraph 49, what the court is saying is that within the various agreements, there was an agreement by the applicant, that is the Swiss people, undertook not to seek registration. And then it continues halfway down. However, it is not apparent from the provisions of the agreement that the intervener, that is the American Omega Engineering Company, undertook not to oppose registration of the trademark. And then it continues, in any event, without it being necessary to consider the consequences of the agreement for the parties, the fact remains that the agreement is irrelevant to the assessment of the existence of the likelihood of confusion.
In the present case.
In the present case, yes. We say that if it was necessary to construe the agreement properly in order to see whether or not there had been an undertaking by either party which would have resolved the matter before them, then they would have had to have construed the license agreement, the coexistence agreement. But their conclusion was, as a matter of law, they didn't need to do that. Therefore, they didn't construe it. My second point here is that in any event, coexistence agreements are not known to the relevant public. And so the first point is, as a matter of fact, as a matter of law, you shouldn't take them into account. But the second point is, as a matter of fact, how can they have any bearing upon the perception of the relevant public? And in this case, you'll be alive to the fact that the claimants and Ralph Lauren were in conflict, but are no longer in conflict. You'll find that in the supplementary bundle with respect to the coexistence agreements. And that the claimants have never been in conflict with USPA. And further, again in the supplementary bundle with respect to the coexistence agreements that are annexed there too, you saw that the defendant's sign 1 was in conflict with Ralph Lauren. And that's their face-on sign, which we say it's not surprising was in conflict with Ralph Lauren's face-on sign. But the defendants have moved to their sign 3, which is the side-on sign. And we say that might well get them out of the hot water of Ralph Lauren, but it moves them into the fire or being in conflict or closer conflict with us.
But even assuming you're right on all of that, where does this have any impact on the judge's analysis?
Well, he seemed to take into account the existence of the coexistence agreement, that those showed that there was no conflict.
Well, where does he say that? Because at the moment, I find it difficult to find any such statement.
And while I try and find the exact reference for that, can I just finish this submission and then I'll come back to you with a reference for that? Because what we say, the existence of coexistence agreements is prima facie evidence that there is some sort of conflict. Because otherwise, why would you go to the effort of trying to draft one?
Well, it might be a purely paper conflict.
It might be still a purely paper conflict, my lord, but at least there's a conflict there. I mean, if you have a coexistence agreement, in some senses, there is a conflict, be it paper or be it actually in the marketplace, but it's been resolved such in the marketplace, eventually the parties can live with it. But it doesn't spring out of no conflict of no sort whatsoever. The starting point is there has to be some sort of conflict. That's the only point I need to make out of that.
In the judgment, in your skeleton, you highlight paragraphs 167, 168
Thank you,
on
my
this
lord.
point, I think.
Well, if it's in the skeleton, those are the paragraphs to which I refer. Then
Well, your junior will, Mr.
Yeah,
Sequin will
that's
put-
what I have. It looks about right.
And he concludes by saying he must still carry out the process of comparison and growth of assessment required by the case law.
Yes.
So what's wrong with that?
Well, it seemed to influence the way in which it feeds into that analysis. So that's all I pray and aid in that sense.
relevant. You say he takes it into account.
It appears so. Because of the way in which he's saying that at one point it says, and I now can't find it precisely, that in essence it's well, he doesn't seem to say that the whole purpose of the coexistence agreement has come out of the font of conflict. He seems to accept the proposition that rather they just now reflect a peaceful coexistence. So it's a nuance.
Well, on one reading in 168, he discusses the existence, the coexistence agreements. But then, as my Lord points out, in the last sentence, says they're not, the views of RAL, which I infer from these, are in no sense determinative. And I must, you could put the word therefore in. I must therefore still carry out the process.
But, my Lord,
Does he take it into account or not?
It's not determinative, but he's not saying that they have no influence.
Or does he come back to them when he's doing his ultimate analysis?
Well, my Lord, I can deal with that after the short
Yes, of course. Right. Would that be a good place to stop? So what have you got left? You've got ground two.
I've got ground two, and that will not take me very long.
Right. How do you think we're doing, Mr. Sutherland, in terms of your...
Well, it depends upon the injury time. I'm hoping to be quite a lot shorter than my learned friend. But there are certain points I want to concentrate on, but you'll appreciate from my skeleton. My position is rather simpler than his.
Yeah. Well, thank you all very much. Look forward to seeing you again at 2 o'clock.
All right, then.